Got it. Okay. Okay, court does call the case of People versus Isaiah Boseman.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Boseman. Mr. Boseman, could you please state your name for the court?
Isaiah Boseman.
All right, this is your motion.
This is my motion, Your Honor. A couple of points. In the prosecutor's response, it does allege that Mr. Boseman was the shooter in the situation.
We're opening strong here. Isaiah Boseman's case is being called in. The courtroom is tense. Remember, this isn't the trial. It's about bond. Will he walk free or stay behind bars? Until trial bond hearings might look routine, but they set the tone for everything that follows. This first impression can decide how the rest of the case plays out.
I actually read the police report to say, and I understand this could be a distinction without a difference, that he's really alleged on sort of an aider and abettor theory as the driver of the car. But I did want to point that out, that I don't believe he's actually alleged to have shot the gun in this situation, Your Honor. Expect the court to drop the bond to a PR bond. He understands that the charges are serious and that's not a realistic situation. Positively speaking, he does have a lot of people that are behind him with their heads screwed on straight. He has a lot of family here that I've all spoken with several times that are really counseling him in the right way and looking out for him and guarantee that they would be responsible for him if he were to have a chance at being released and going home, and making sure that he stays home, Your Honor. So again, we understand that the court would not likely drop this down all the way. We understand that, but we would appreciate any of the court's consideration.
The defense just asked for a bond reduction. Smart mover right instead of pushing for full release of theory, trying to sound reasonable. It's like saying we not asking for the moon, just a little fairness. But here's the catch. The judge knows reducing bond means more freedom for someone accused of serious crimes. That balance is tricky.
In reducing the bond, Your Honor.
And you understand the people's request to raise the
bond? I didn't read the request to raise the bond, Your Honor. I am hoping that that's not the case, but since we're standing at $1 million as it is, it's quite high as it is, and realistically, he'd never be able to post it as it is now. So $1 million or $500 million.
Respond.
Your Honor, Mr. Coconut,
Boom, the prosecution drops a bombshell random rifle shots into homes. That changes everything. Judges take public safety dead serious. We've got gunfire endangering families in their own houses suddenly. It's not about fairness, it's about preventing the next tragedy. This single statement could crush the defense's chances.
I read it just to deny the defense motion.
I may have been looking at it, but go ahead.
We discussed the facts. It does involve effectively random shooting of a rifle into occupied buildings in our community. This is a 21-year-old individual, and while I appreciate he has support from people that are there to support him, as stated earlier, they were probably still around a month ago when this was happening. And so our concerns for the safety of the community remain in place, and I'd ask that the motion be denied.
In the courts of the situation.
Well, the factors that the court has to take into consideration looking at this, there's one issue as to whether or not the original bond that was set was an abuse of discretion. This court doesn't find that it's an abuse of discretion, but then looking at the numerous factors, or the factors, the primary of which are the safety of the community.
Listen closely here. The judge calls the act senseless. That's not a legal word. That's raw human frustration. Judges rarely step out of their formal tone unless they feel the weight of what could have happened. This moment shows us the judge isn't just analyzing statutes. He's imagining lives lost, and that makes the decision feel personal.
As well as the defendant's risk of flight. I don't particularly view the defendant as a risk of flight in this case, having read all of the support that he has around him. I think the problem will be, I do view him, though, as a significant risk to the community. That is really my big issue. When you start firing a weapon off into an occupied dwelling, that type of an event. You're right, Mr. Bernstein, that's a distinction without a difference. as to whether or not one's the driver and the other. But if you're aiding and abetting in that type of behavior, you are a significant risk to the community. There could have been a number of people that would have lost their lives by this behavior.
Decision time. Bond stays as it is. The defense may have argued, but safety trumps sympathy. Notice how quick the judge is here. Hey, doesn't hesitate. That confidence tells you he's convinced beyond doubt that lowering bond would be reckless. Isaiah Boseman will remain in custody and the defense walks away empty-handed.
Which would have just been, quite frankly, at least as I understand.
So here's the big question for you. If you were the judge, would you take the risk of lowering bonder? Do you think keeping Boseman locked up was the only safe option? These are the tough calls that spark debate. Let's hear your thoughts. Is the judge being overly harsh, or is he protecting the community?
Some of the background on this would have just been absolutely senseless. It makes no sense. So since I do consider the defendant to be a danger to the community, despite the overwhelming support that he has, I think it's a good point what the prosecutor indicates, that that support was there before. And quite frankly, I realize these are allegations, but before he got himself involved in something like this, he should have reached out to the support that he has around him to be standing before today with the folks that are around him and could support him if they needed to. So for those reasons, the court is going to deny at this time the defendant's motion for bond reduction. Bond will continue.
Appreciate the consideration, Your Honor. See you next week.
We have another follow-up conference.
Oh, yes, PCC, yes.
Yes.
The co-defendant's case was this morning, Your Honor. Did that get adjourned to a date? Could we track with that? Fred Willis?
Did I think it was the 14th. 14th, no.
Yeah, will that work for you?
Yes, Your Honor. Thank you.
All right, I'll adjourn the probable cause conference in this case to August 14th, 2025, 9 a.m. or as your invite indicates. Bond will continue. Thank you. That's called the case of the people versus Jaylen Christ.
Yeah, I was gonna say, Ken Reddish on behalf of Mr. Priester. Can you say your name for the record, please?
Jaylen Christ.
Your Honor, today before the raise defendant's bond, $75,000 after the development of that provision, and in the event of defendant's release, require a home confinement tether. We make this request on the basis that defendant is a dangerous individual who poses a threat to the community's physical safety. He fired a 9mm pistol at least 5 times into an occupied apartment building, striking apartments aimlessly. MCR 6.106H allows a court to modify bond if they find that there is an abuse of discretion. The current bond of $35,000 represents an abuse of discretion outcome under the factors laid out in MCR 6.106F and MCL 756.6. I laid out the 9 factors under MCR 6.106F in my brief and will leave those to the court's consideration. Both of my argument is focused on MCL 756.6. This includes 4 factors. The first of which is the improbability of defendant appearing at future court dates. We don't have much to say on this factor. We would simply note that defendant was arrested for assault and battery in 2018 and attempted to flee uniformed officers at that time. Moving to the second factor, the seriousness of defendant's charges. They are very serious. There's a maximum penalty of 10 years in prison, and people have calculated sentencing guidelines between 5 to 23 months. The statute that defendant violated is designed to protect people in their own homes and in common gathering spaces, places we shall be free and safe to be in. The third factor is the protection of the public. The bond remained as is. Defendant has a reputation for being in a gang. He sent death threats to a victim via text. He tried to run that same victim off the road with his vehicle. And one of the neighbors, who was a victim of his shooting conduct, was awoken from her bed by a bullet passing through her window, past her head, and then ultimately embedding in her mirror. Defendant's conduct has escalated from targeting one individual to threatening an entire apartment building of people in Washtenaw County. We would have serious concerns if bond remained as is. Finally, defendant has an extensive criminal record and a reputation for being dangerous. His clemency history shows at least 33 interactions with law enforcement over the years, 8 of which resulted in arrest. These included using his telephone for harassment, larceny, and CS. He has demonstrated a severe lack of concern for human life and a willingness to fire a deadly weapon even when there is a deadly risk to bystanders. Defendant is a dangerous individual and a factor under MCL 756.6 support raising bond. He fired a weapon at least 5 times into that apartment building at 3 p.m. on Memorial Day, a date and time when people were particularly open to vehicle. He threatened their safety inside their own homes, a place that they should be particularly safe and free from defendants' aimless bullets and violent tendencies. Instead, their holiday was interrupted by bullets piercing their apartments. One woman again was woken from a nap on her holiday by a bullet passing through her window, past her head, before bedding in her bathroom mirror. Therefore, the people request that the court raise defendant's bond to $75,000 cash surety with no 10% provision and a home confinement